Good morning, this is your Kelso Report for Tuesday, April 23rd. I'm your host, Clark Kelso. The Supreme Court addresses the issue of the extraterritorial application of the Alien Tort Statute in our first case, and also looks at the warrant requirement in the context of a blood test for driving under the influence. The Ninth Circuit gives us a decision involving plan reimbursement for medical expenses under the Medicare Act, and, in another case, puts the brake on certain types of class action settlements involving incentive payments to class representatives. We begin with the Supreme Court. The rarely invoked Alien Tort Statute provides that the district courts shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. The question before the Supreme Court in Kelso versus Royal Dutch Petroleum was whether the Alien Tort Statute applied extraterritorially to torts committed in a foreign country by one foreign national against other foreign nationals. Factually, the case involved a group of Nigerian nationals residing now in the United States who filed suit in federal court against certain Dutch, British, and Nigerian corporations, alleging that the corporations aided and abetted the Nigerian government in committing violations of the law of nations in Nigeria. The Supreme Court held unanimously, although with separate opinions and reasons, that the statute did not apply extraterritorially, following a traditional canon of statutory interpretation that raises a presumption against extraterritorial application of the law. This canon of interpretation reflects the practical reality that, while United States law governs domestically, it generally does not rule the world. Since all of the relevant conduct occurred outside the United States, the court held the Alien Tort Statute did not apply. Next, we turn to warrant requirements and driving under the influence. There is a tension in the Supreme Court's search and seizure cases between developing relatively clear rules of law, rules that are often phrased in categorical terms, and resolving the question of reasonableness on a case-by-case basis, where the results are rather fact-sensitive. For law enforcement personnel faced with the question in the field of whether to conduct a search or seizure or whether to seek a warrant, that tension is particularly plain to see. They would probably favor categorical rules that are easy to be trained on and easy to apply. But those categorical rules are often under-inclusive or over-inclusive, which pushes the court away from categorical rules and towards a more case-by-case approach. This tension was in full view in the Supreme Court's decision in Missouri versus McNeely, which involved a warrantless blood test of a driver suspected of driving under the influence of alcohol. The driver had refused a breath test in the field and was taken into custody and had a blood test taken at a hospital without a warrant. Now, almost 50 years ago, in Schmerber versus California, the Supreme Court upheld a warrantless blood test of an individual arrested for driving under the influence of alcohol because the officer might reasonably have believed that he was confronted with an emergency in which the delay necessary to obtain a warrant, under the circumstances, threatened the destruction of evidence. Well, in last week's case, the court addressed the question whether the natural metabolization of alcohol in the bloodstream presents a per se exigency that justifies a categorical exemption of the Fourth Amendment's warrant requirement for non-consensual blood testing in all drunk driving cases. After reviewing its Fourth Amendment cases, the court concluded that a per se rule was inappropriate and held that exigency in this context must be determined case by case based on the totality of the circumstances. Justice Kennedy was the all-important fifth vote in this case, and in his separate concurring opinion, he suggested that the court might in the future find it appropriate and necessary to consider a case permitting it to provide more guidance than it undertakes to give today. Kennedy noted that the only issue ripe for decision in this particular case was whether a state could always dispense with a warrant for a blood test in every case when a driver is arrested for being under the influence of alcohol. That blanket rule went too far for Kennedy and the majority. So for additional guidance from the Supreme Court, law enforcement personnel are going to have to wait for some further case developments. Next, we turn to a Ninth Circuit decision involving Medicare expenses. It is an important decision that the Ninth Circuit reached about federal jurisdiction. The Ninth Circuit held in Para versus Pacificare that the Medicare Act does not create a federal cause of action in favor of a Medicare Advantage organization plan against a plan participant's survivors for reimbursement for advanced medical expenses out of the proceeds of an automobile insurance policy. Now, there's no question that the Medicare Advantage organization plan provides secondary coverage, and that the MAO has a right to charge a primary coverage or primary plan for any conditional payments that the MAO has made on behalf of a plan participant. The recognition of that right is the basis for language in the plan contract that supports a state law cause of action for breach of contract. But the federal statute does not create a cause of action for enforcement of that right, so there is no federal court jurisdiction for enforcement, and the MAO plan is relegated to a state court claim for breach of damages. It's an important case that's going to reduce the jurisdictional reach of federal courts in cases involving reimbursement of health plan expenses. I suspect those cases are going to be increasing in number substantially in coming years. Next, we have a case involving class action settlements. In an opinion that sends a shot across the bow of class action settlement practices, the Ninth Circuit has rejected a class action settlement under the Fair Credit Reporting Act. The settlement in Radcliffe v. Experian Information Solutions contains substantial conditional incentive awards for class representatives who supported approval of the settlement. Although the Ninth Circuit has previously approved non-conditional incentive awards for class representatives, the panel rejected the conditional incentive award because the awards caused the interests of the class representatives to diverge from the interests of the class members. In addition, the panel was concerned that the size of the incentive awards significantly exceeded in amount what absent class members could expect to get upon settlement approval. In particular, the settlement incentive was up to 10 times larger than individual payouts under the settlement. In short, you can't load the deck in favor of the class representatives in order to coerce them into approving a settlement. And that's it for today's Kelso Report. Have a great day in the law.